Can we have another round of applause for Elizabeth? Thank you very much. Next up is Jojo Anobil, who is the attorney in charge of the Immigration Law Unit at the Legal Aid Society. He's also on the adjunct faculty at New York University Law School. Jojo Anobil.
Hi, good morning. I know you just had a presentation that was very lively, and I'm hoping that I can keep you awake. I know it's getting close to lunchtime, so let's see how best we get through this. So what you've done so far, and I just caught the end of this whole presentation, is looking at adjustment of status. And what I intend to do is to look at some of the issues that come up that needs to be flagged. It used to be that it was very easy to complete an adjustment of status application. All you had to do was to take the form, the I-130, 485, and you are home free. It's no longer the situation. And one of the things you have to do if you are either a lawyer or an accredited representative who is working with immigrants is that you have to be very careful when you're going through the person's immigration history, how the person got here, whether the person has any criminal background, family, applications that the person has filed previously, and sometimes you may even need to file a Freedom of Information Act request trying to get the person's file just to be sure that whatever you're going to complete for the client is very consistent with whatever the client has previously provided to immigration. So just to start off, you talked about one of the eligibility requirements for adjustment of status is that the person must have been inspected and admitted. There are all kinds of differences to that when you talk about an admission. So a lot of times I'm not talking about someone who comes in with someone else's passport. I'm talking about people who come in through a port of entry, who are waived in. So Jose, who is traveling in a Highlander with two other couples coming across the Mexican border, stopped at the border. The officer asked the driver, "How are you doing? What's your immigration? Are you a U.S. citizen?" He says yes and says, "Okay, have a good time, go." That person has been inspected, okay? The person who is Mexican or comes from another country who is in the car at that time, there was an inspection. The officer asked someone about his or her status and then waved the car through. That is an inspection. However, and so you could use that for an adjustment purposes. Is it easy? No, it's not. Because you also have to be able to prove that the person made that was inspected and admitted. So it comes down to credibility. Oftentimes you will lose at the USCIS level and have to, once it's denied and the client is placed in proceedings, then you have to go through removal proceedings to be able to convince the court and also convince the trial attorney that, yes, indeed, you came through the airport, you came through a port of entry, you have affidavits of people, either those who were in the car at that time with you. So, for example, there was a case recently where there was a young boy whose brother got burned in a fire in Mexico 10 years ago, 15 years ago. And the family decided to take him to LA for medical treatment. The boy's brother and an uncle, a year later, decided to go to LA to visit him, and so walked across the border. He was able to show through affidavits that, yes, indeed, he walked through the border, they met with an officer, the officer said, "How are you guys doing, everything okay? Okay, go." And as a result, he lost at the USCIS level, but in front of the immigration judge, was able to prove that, yes, they made an entry and they were inspected at that point. It's a little bit complicated, and so it's not one of those, it's not for the faint-hearted when you're doing these kinds of things. Don't put your client at risk of removal. You have to investigate it. You have to make sure that you know exactly how the person came in. if the person can get corroborative evidence to show that the person came in through the border entry and was inspected at some point in time. I'm flagging these things because there's case law on it, and it could be someone's only chance of adjusting status because they came here at some point in time, walked through the border, now they are married or have an opportunity to adjust, but they don't have any way of adjusting. Fortunately, there are proposals now that if you're an immediate relative, you are a spouse or a child, you would be able to get a waiver here in the United States before you travel abroad when you trigger the 10-year bar. So what I'm saying now may not be relevant probably a year from now, but I'm just flagging it for you, okay? There was also talk about those who are ineligible for adjustment of status. You went through that. There are those who are ineligible and those who are restricted. So for example, the examples I give you up here, someone who is not a beneficiary of an I-130, or someone who came in on a fiancé visa, and the marriage didn't work out, and now wants to marry another US citizen to petition for him. When you come on a K-1 visa, you can only marry the person who brought you here. There are exceptions, and we'll talk about that. Also on the conditional residence, someone who is a conditional resident, the status has not been terminated, and decides that I no longer love Harry, I love Jim, and so look, Jim is also a US citizen, so Harry, go away. Jim, you are the new guy on the block. No, it doesn't work that way. Ineligibility, you also looked at crewmen. You looked at those who are coming with transit visas. So someone who is passing through the US to another destination, but decides when he gets to JFK that I think I need to stay here, and then just walks out of Kennedy Airport. You can't adjust your status. Crewmen could be those who are coming off a ship, getting off a ship as a crewman because the ship docked at Miami. Or someone who is coming here because he's coming to join a ship, coming to join a cruise ship, for example, to work on a cruise line, and decides when he gets to Miami that I saw the Miami Heat play yesterday, I love them, and I don't want to go back, I don't want to go on the ship, and I can just stay here. Well, you cannot adjust your status because you'll be ineligible as a crew member. Then there were the immediate relatives who who are not subject to the employment authorization or lawful status. And also we talk about the visa waiver program, which I'll talk to you about later in one of the slides. Now, when they talk about this, the 245I, there are certain groups of people who are grandfathered and can take and are able to apply under 245I. When you're talking about derivatives, you're talking about spouses and children. At the time that the application was filed, either before January 14th of 1998 or before April 30th of 2001, there must have been a relationship that was established. The person was the spouse or was a child at that time, okay, to be able to take advantage of 245I. Or a second group would be at the time the principal beneficiary filed the application for adjustment of status, that relationship being a spouse or a child had formed. Okay, so there are two instances. It doesn't matter that at the time that when the spouse was married to the principal, it doesn't matter that in between that there was divorce. Once the person is grandfathered, it doesn't matter whether later on the husband divorces her, she can still take that I-130 approved filing and be able to file for adjustment of status. So as was mentioned previously, the key dates are you're looking at any application I-130 filed before January 14th of 1998 or before April 30th of 2001. They are key because of this. You would need to show that the principal beneficiary, if you're filing on behalf of the principal beneficiary, and the application was filed between January 15th, 1998 and April 30th of 2001, you'd have to show physical presence, that the person was present in the United States of America as of 12/21/2000, okay? You don't need to show fiscal presence for derivatives, meaning the spouses and children. If the application was filed prior to January 14th of 1998, 1998, you don't have to prove fiscal presence, okay? And I'll talk about fiscal presence in a minute. I just talked about the grandfathered, those who are grandfathered. Now, a couple of things that you have to know before you even file the 245I. It costs $1,000, it's very expensive, and so don't just file it because you just think that your client is eligible. That is why when you are doing your initial intake, you need to find out from the client, do you have any parents? And did your parents have any brothers or sisters? Do you know if they filed any applications for them? Do you, as a person, also have any brothers or sisters? It's very extensive. It goes all the way to grandparents. But the application must have been properly filed, okay? What does that mean? So the application was filed before April 30th of 2001, but was filed with a wrong application fee. It's not properly filed, okay? It was filed, instead of $85, someone sent a check for $110. It's not properly filed, okay? And you're gonna have problems. It must have been sent to either the then INS location or a USCIS location. If it wasn't sent to that location, you are out of luck. So you have to be very careful when you look at these 245I situations, when they talk about properly filed. Properly filed also could mean that it was postmarked and received as of May 3rd of 2001. When you're looking at some of those applications, those receipts, okay, notices of action, 797, don't just look at the receipt notice and dismiss it as, oh, it's May something and so you're out of luck. All I know is that I went to this training, I was told April 30th, I see here May something and so you're out of luck. Read the body of the 797 notice of action, because oftentimes in the body they will tell you that it was postmarked as of May whatever date, and as a result the person is eligible for 245I purposes. I've seen it happen a lot of times. When for advocates, just look at the receipt date at the very top on the left-hand side and just make that determination that it's beyond 4/30/2001. The other thing that you have to look is it must have been approvable when filed. So first, it was filed properly, approvable when filed. What does that mean? So, for example, the application was filed by an aunt for a niece. Okay, an aunt cannot confer benefit on a niece, okay, for adjustment purposes. So it's not approvable when filed. Approvable when filed usually would mean also that at the time that it was filed, let's say you filed the application and the application had no supporting documents. It was signed, which is a requirement. The I-130 was signed. However, you did not include any supporting documents. It will be deemed approvable when filed, because what is going to happen is that you're going to get an RFE, okay? Because there's also another part of it which says that it doesn't matter if later on it's withdrawn, revoked, or denied, okay? The most important thing is it was approvable on the date it was filed. It doesn't matter that after it was filed on 4/30/2001, in June, the marriage broke up. At the time it was filed, it was approvable, okay? So that's also key. We talked about fiscal presence, and for those, and basically what I said earlier on is that for fiscal presence, you're dealing with the principal beneficiary, and it's for applications filed after January 15th of 1998. How do you prove that? So, for example, it may be that the person has an INS notice, or has the 797 notice of action, dated probably in 2000 or 98. That could be one of the things that the documents that you use. It can be anything that shows that the person was here on December 21st of 2000, or any time before then, or soon thereafter. So apart from that, you can also use government documents. For example, driver's licenses, W-2s, tax returns are all possible. You may ask me, what about the client's affidavit? There's not much weight given to a client's affidavit because it's self-serving, okay? So you need, for example, a lease, a copy of a lease, hospital records, school records for children, birth certificates to show that the person was here. Those are the things that will go to show this. We talked about, and those would demonstrate the fiscal presence. The next thing that I want to talk to you about is the visa waiver program. The visa waiver program was established for countries that send a lot of people to the United States, and they are deemed to have good economies, and so most people come here and will not stay here. And so the government gives them the privilege of not going to a consulate or an embassy to apply for a visa, and rather they take their passports, buy a ticket, get on the plane, and show up at Newark or JFK. However, they're only allowed to stay here for 90 days. At the end of the 90 days, they're supposed to go back to wherever they came from. Unfortunately, sometimes they love America, they love the Statue of Liberty, they love seeing Ground Zero and decide to stay, okay? Or sometimes they love Century 21 and think this is the best thing that happened. But there are problems. If you have someone who came on a visa waiver program, it's for 90 days. Unless the person is married to an immediate relative, the person cannot adjust status, okay? In New York, it doesn't matter when they get married to the US citizen. If they get married to the US citizen way past the 90 days, they are allowed to adjust. You cross the river to New Jersey, it has to be within the 90-day period. If they get married outside the 90-day period, they cannot adjust status. It's the same with the 7th Circuit and the 5th Circuit, which deals with Texas and Louisiana. In those places, you have to get married within the 90 days. So when someone comes to see you regarding the visa waiver program and wants to change status, you have to look at it carefully. Usually the I-94, it's an I-94W, WB, WT, and they're green in color. It's not white, it's green in color. But you have to be careful with the visa waiver program because they can't change status just like that, just because they are here. They have to change, they can only change status if there's marriage to an immediate relative, okay? You have your K and K2 entrants. So you have folks who came here as fiancés, are supposed to get married within a certain period of time, and then they can adjust status. Earlier on, I had mentioned that once you come under a K1, you can only adjust status through the person, the spouse who brought you here. An exception is when, for example, there's been abuse and so you can file a VAWA claim, then you can adjust through VAWA. But recently, there's case law which indicates that even if the marriage has been dissolved, it's possible still to adjust, provided the marriage has been in existence for 2 years or more. Again, a little bit complicated. You have to read the case, and I have the case law up there. But the basis of that is that after 2 years, the client is no longer subject to the conditional residence provisions. And as a result, the court in this case, say, allowed the person to adjust status, even though the marriage had been dissolved, because it basically said that the person had complied with the conditions of a K1 non-immigrant visa holder coming here, getting married within the 90 days, and file the application. And so even though the marriage was dissolved during the pendency of the application, because it was past the 2-year period, the person was allowed to adjust status. Children usually come in accompanying the principal, the K1, into the United States, sometimes age out. It used to be that the moment they age out, USCIS tells you that they can't adjudicate the application. Now, some case law that's come down seems to suggest that they can do that. And so that's also something that you should keep in mind. The other thing you also see sometimes is you come across refugees and asylees who are trying to adjust status. So refugees and asylees can adjust status After a year of having that status, a refugee is someone who is outside the country and claims that he or she is in fear of being of persecution, or has a well-founded fear of future persecution, and so is granted the status and enters the country as a refugee. Or someone who is an asylee comes into the country and says, I'm afraid of going back to my country because my country can't protect me because of various things, either because of political opinion or because I'm gay and there's gay bashing in my country, or because I'm female and they practice female genital mutilation, and the government grants you that relief, asylum. After a year in that status, you can apply for adjustment of status, okay? There are certain things we've talked about that does not apply to them. For example, there's no public charge issue. They don't have to apply, they don't have to fill an affidavit of support. But what happens is that sometimes some of these folks may have had contact with the criminal justice system. If you have a client who has had those contacts, you need to reach out to someone who understands that area, the intersection between crimes and immigration law, for the person to work on those cases, because there are special waivers for asylees and refugees. It's under Section 209C of the Immigration and Nationality Act, which will waive almost anything which makes someone inadmissible, okay? The only thing 209C will not waive are drug sale convictions, or where you have a conviction that is termed to be very dangerous and violent. So for example, there was a woman who was a babysitter and taking care of a kid. The kid wouldn't stop crying. She smacked her a couple of times on the butt. The kid wouldn't stop crying, so decided to shake the kid, and suddenly the kid wasn't breathing. Put the kid back in his cradle and went shopping. Came back, and the parents came in, and suddenly he says, I didn't know what happened. He was sleeping when I left. So this lady who had asylum applied for adjustment of status. She was able to show, in balancing the act, that she was a good person and that this was an aberration, and the immigration judge granted relief. However, when it went up to the Board of Immigration Appeals, it was sent over to the Attorney General. The Attorney General, looking at it, said, I don't think so. I think this is someone who doesn't deserve adjustment of status. And so anytime you have any convictions where you can label them as a bit dangerousness or is violent, you have a problem, okay? So that is why I flagged this. Yes, there's relief available, there's a waiver available to waive almost anything, excuse me, but it will not waive drug sale convictions, and it will not waive issues dealing with crimes which are deemed to be dangerous and violent. Okay. False claim to US citizenship. How does this come up? So a lot of times you go for an interview and suddenly the adjustment officer is asking about employment. So have you been working? And we all know that, we just saw it, that if you have worked without authorization and you're married to an immediate relative, you are home free, okay? However, you're not all the way home, because there are questions that can be asked. For example, so you've been working. Oh yeah, I've been working for a few years now and I've paid taxes and everything. Okay, fine. So now the question comes up, can you provide your I-9? When you show up at a new job, you are required to complete an I-9 form, which indicates you check off a box that says you're either a citizen or you're a national. So sometimes the adjustment officer says, can you provide that? And woe betide you. You probably checked off the box that said you're a citizen. You have a problem, okay? You have a huge problem with false claim to US citizenship, which probably you may not be able to waive, okay? So you have to be very careful when you're doing your initial interviews and the person has worked before. You need to ask those questions, okay? Is it okay to just say, well, I don't want to ask because I don't want to know the answer? Well, I think you need to ask because you need to know the answer, because you don't want to be in that room with that client and suddenly that question pops up and your client is asking you, but why didn't you ask me before? And you're like, well, I didn't want to know the answer. That's not good. Ethically wrong, okay? You need to know to be able to advise a client accordingly that because of A, B, C, or D, unfortunately, I can't prepare this application for you because I'm going to put you at risk. It comes up very often. It could be welfare benefits that the person applied for. It could be that, and I've seen it happen, where those who are not eligible for even U.S. passports go in and apply for a U.S. passport, okay, using someone else's documents. That is false claim to U.S. citizenship. I'm not talking about coming into the country with a U.S. passport. That is also false claim to U.S. citizenship and could also bring you under this provision. So we saw that a lot when we're doing the Haitian TPS cases, where those who came in with U.S. citizen, we came in using a U.S. passport are deemed ineligible for certain benefits. So you have to be very careful when you're dealing with this issue of false claim to U.S. citizenship. Voting is another thing. You know, like most people tell you that, oh, I was just walking down the sidewalk and there was this guy with a table and he said, oh, I should register to vote and Obama needs my vote. And so I said, oh, sure, you know, I'll do that, you know. Well, that registration form has a box that says, are you a U.S. citizen, okay? And it may be that you are telling the guy, no, I'm a lawful permanent resident. He says, oh, sure, that's okay. And he checks it off for you and you sign it, okay? That's false claim to U.S. citizenship, okay? So you have to be very careful with that. There's an exception to that, an exception where someone who came here, who is a lawful permanent resident, came here before the age of 16, both parents are U.S. citizens, and decides, and so claims to be a U.S. citizen. We see that a lot for lawful permanent residents who are trying to apply for U.S. citizenship, and tell you that probably they were in college and probably voted because they had always assumed, they came here at age 3 and had always assumed they were U.S. citizens. Okay, nobody told them anything otherwise. And so as a result, they voted. So there are things that you have to look at when you're dealing with voting, dealing with benefits, dealing with I-9 forms. I-9 forms are because the officer will ask you for it. They'll give you that form called N14 and ask you to provide it. You have to go to your employer and get a copy, and before you know, you're out of luck, okay? The other thing that we also deal with when you're dealing with adjustment has to do with fraud and misrepresentation, okay? A lot of times, fraud needs to be willful. When you're dealing with misrepresentation, it doesn't necessarily have to be willful. So take, for example, that you are asked a question about children, okay? And again, this is something you have to do in your practice. So the person is asked if he or she has any children. You filled out, you completed the I-130, which is blank. When you go to the second page, no children, okay? And the question is asked, do you have any children? With a bold face, no, right? Okay. So it happens that let's say you're given the status, and I'm going beyond what I was asked to do today. But let's say you apply for naturalization, and suddenly you put down 6 children, okay? You have a problem. That's misrepresentation. You have a huge problem. Why? Because you cut off a line of questioning. You did not allow the officer to ask you questions at the I-1 adjustment interview about the children, okay? So you had a baby, 2-month-old baby, you flew to the US to visit mom, left the baby behind, fell in love, and you got married, okay? But someone, as they always say, someone told me that, or the person who prepared the application told me that I did not need to put down my baby's name because it wasn't necessary. Yes, it is, okay? The officer wants to know. They are looking at the bona fides of the marriage. And so when you're talking about misrepresentation, you have to be very careful. Is it material? It's material if it makes you inadmissible. If there's some information that would make it impossible for you to get the status, so you were arrested and you pled guilty, but you failed to put it on that application, and as a result, and it didn't show up on the FBI rap sheet that was generated when the client submitted fingerprints. If that conviction would have made the client inadmissible, then it's a misrepresentation, okay? Can you retract? Yes, you can. So the client comes to you, you ask him all the questions, he doesn't tell you that he's been arrested or he doesn't tell you about certain things, And then later on, when you are preparing the client for the adjustment interview, suddenly he trusts you so much that suddenly he's giving you all this information, okay? You may need to go back at the interview and retract some of the things you've said or some of the things you haven't said. You need to correct the record. You can retract before the officer makes his or her decision. By the time they make it, that's it. The books are closed. It's different if you just kept silent. You didn't say anything, or you weren't asked. Sometimes the officers do that. You may have a situation you're at an adjustment interview, and the officer is zipping through all the questions, and he doesn't ask you certain questions, and so you don't say anything. That's silence. That's not misrepresentation. Okay, so there's a difference. But again, the misrepresentation has to be material. It has to go to inadmissibility, either make or break your case to be a misrepresentation and also fraud. Now, if you came in with someone's US passport, or if there's misrepresentation or fraud, you need a waiver. Usually you need a 212I waiver, which is usually, you use a 601 waiver form. But you have to be careful because there are qualifying relatives that applies. You either need to be the spouse or the son or daughter of a US citizen or a lawful permanent resident. You realize there's nothing that says a parent. Okay, it doesn't talk about a parent. It says that you must be a spouse or the son or daughter of a US citizen. It doesn't say parent. So if it's a parent, and there's misrepresentation by the parent who is being petitioned by the son or daughter who is a US citizen, that parent is ineligible to waive the misrepresentation, okay? It may confuse you that it says spouse and parent, but you're showing extreme hardship to the spouse or parent. The spouse, parent to child. The child saying that if I'm not allowed in, it will be an extreme hardship to my parent. But a parent who is an immigrant is not eligible for this waiver. Okay. Criminal bars to adjustment, very briefly. So there are certain things that will make someone ineligible for adjustment of status. A drug conviction, any drug conviction, apart from a drug conviction of 30 grams or less of marijuana. Anytime you have a client who says, oh yes, back in 99, 2000, I was arrested, I pled guilty to possession of cocaine, your client is dead in the water. You cannot adjust status. There is no waiver, period. Okay? So that's a cardinal thing. Anytime the client has such a conviction, the client is ineligible for adjustment of status. What can you do? You should try and reach out to any of the organizations who specialize in the intersection between crimes and immigration and ask them to see your client and see if they can help your client. There was a case that came down recently called Padilla versus Kentucky. Padilla versus Kentucky basically says that criminal defense attorneys have a Sixth Amendment obligation to inform their clients about the immigration consequences of a criminal plea, okay? And it's very possible that your client did not get such an advisor and may be able to vacate that plea. Otherwise, your client is ineligible for adjustment of status. Theft offenses, jumping a turnstile, could be a problem, okay? Pulling your friend's hair and getting reported and taking a plea to assault could be one of those things that prevents you from adjusting status, okay? Prostitution is also one of those things. Reason to believe a drug trafficker. So you were coming into the country and you claim someone gave you a suitcase, 150 pounds of marijuana in your suitcase. And suddenly you're claiming you had no clue, but you've been going to court so many times and decided, what the heck, let me just take the plea and go home. You have a problem, okay? Because there's reason to believe, according to the government, that you are a drug trafficker, okay? So those are criminal bars. You can waive some of the criminal bars, as I mentioned, with 212H waiver. 212H waiver, again, why I said the 30 grams is it will only waive 30 grams or less of marijuana. It won't waive anything else. 212H will waive most grounds of involving crimes involving moral turpitude. There's been new case law regarding lawful permanent residence and the eligibility for 212H. I won't go into it now because it's a little bit complicated and the law is in flux, but I just wanted to flag that. So let's say at the end of the day, one of the things that was touched, and I just wanted to touch on briefly, was that it all comes down to discretion sometimes. You may be eligible. Statutorily, your client is eligible for this status, okay? But either the adjustment officer or the immigration judge has discretion to decide whether to grant the application. And sometimes you're looking at discretion. Discretionary factors includes how long the person has been here, ties to a U.S. citizen, lawful permanent residence, what the person has been doing whilst here, filing taxes sometimes goes into the equation, but there's this whole area of discretion. And so it could be that the person, for example, has gotten arrested a bunch of times for, let's say, possession of marijuana, and every time got a disorderly conduct. An adjustment officer may decide that, look, you don't deserve on discretion, you don't deserve to be granted adjustment of status. It's discretionary, okay? And it can go up if you want to appeal it. Now, if the application is denied, your adjustment of status application is denied, you can do one of two things. You can file a motion to reconsider or a motion to reopen because you think the adjustment officer was too harsh on you. You can do that and you can pay the fee. Or you can wait 45 days and USCIS will refer your case to an immigration judge. If you indeed have a good case, then all you're doing is renewing that application before the immigration judge. It may take a while because these days in immigration court it may take you 18 months to be able to complete that case. But you'd need to refile, you'll be asking the judge that you'll be renewing the adjustment application in removal proceedings. You don't have to pay another fee to do that, okay? But so there are two different tracks. You can either wait and get placed in proceedings, that's your client, or you can file a motion to appeal the decision. Okay, and that's usually called a motion to reopen or a motion to reconsider. It's been one of those areas under adjustment of status where it used to be that once it's denied, you are just in limbo, you go about your business, and later on if you find someone else that can help you, you come back and do it. It's no longer the case, and oftentimes USCIS will place the client in removal proceedings. One of the things that I failed to touch on going back to 245I is this. For 245I purposes, you can file that application multiple times, and multiple times pay the $1,000 fee. The moment you get status, you obtain status as a lawful permanent resident using 245I, you can no longer go back again and try and use it. So anytime you're using 245I, the person could use 245I with marriage 1, marriage 2, marriage 3, marriage 4, marriage 5. You're rolling the dice, and you're paying the $1,000, okay? But the moment everything goes through with marriage 7 and you're granted, and things don't work out, there are problems with the adjustment, and you're coming back, you can't adjust again with marriage 8 using 245I, okay? They will take your $1,000 anytime you try to do it. And one of the things you have to realize is that bona fides of the marriage, okay? So we talked about approvable when filed. If, let's say it was through wife number 1, who you've divorced, and now you're married to wife number 2, and you're trying to get status through that, USCIS is going to ask you about the bona fides of marriage number 1. So you should work with your clients to come up with documentation to prove that they had a bona fide marriage when that application was filed on April 30th, before April 30th of 2001, okay? I realize it's lunchtime. I think I zipped through this. I'm sorry if I was rushing too much, but I have somewhere else that I have to go, so I'm very sorry. I hope that the rest of the day is productive, and thank you so much.
It's not lunchtime. We're going to have a short question and answer segment.
Okay, thank you very much, Jojo. Can we have a 2 seconds, please? Hello? We're going to move on to the Q&A portion of the session. We're joined by Alan Warnick, the director of the project, Julie Dinnerstein, who gave the initial presentation, and Midori Hills, who is our staff attorney at the York College Center. So we will address your questions.
Before we get to the questions, we'll do the best we can to answer them. But one thing I wanted to point out, I thought Jojo's presentation was outstanding. But what we tried to do this year, because we have so many repeat guests at our trainings, we tried to provide some more advanced aspects of immigration law. But the key thing about the call-in is not to try to answer necessarily those difficult questions if you don't feel capable of doing it. Remember, the point of being on the phone is also to remember that you have somebody behind you who is an attorney or an accredited representative who will assist you. So if you didn't get everything that Jojo talked about or any of the speakers today, that should not discourage you in any way from participating. I'm sorry, so go ahead.
Right. First question, Maggie?
Okay. Can a U.S. citizen child who's over 21 apply for his or her step-parent?
Can we have Julie answer that?
Somebody else want to answer that? The answer is, if the step-parent-stepchild relationship was created before that U.S. citizen's 18th birthday, then yes, the U.S. citizen can sponsor the step-parent. If it was created on or after the 18th birthday of the U.S. citizen, then the answer is no.
Thank you, Julie. Monique?
Just a quick comment. We found a pair of glasses. If anyone missing the glasses, is brown framed. Alrighty. Can a grandparent petition for their grandchild?
Julie again?
So a grandparent cannot file a direct petition for their grandchild. However, and we saw this in the first petition where we had Rosemary, I believe, had become a U.S. citizen, and she could file a direct I-130 for her child who was over 21, so a preference category 1 petition, and then when that preference category 1 petition was approved, then the grandchild could come in. There is no direct petitioning for grandchildren, however. So if you have a grandchild coming in as a preference relative, either under preference category 1, preference category 2A, or 2B, so adult single child of a U.S. citizen, or married, so it's preference category 1, single adult child of a U.S. citizen, preference categories 2A, 2B, which are children either who are unmarried, either under 21 or over 21 of a green card holder, or preference category 3, a married child of a U.S. citizen. If you're coming in under any of those preference categories, if the direct beneficiary has a child who's unmarried under 21, then that child can come in as a derivative on the preference relatives case. If your child is under 21 and unmarried and you're a U.S. citizen, so your child is an immediate relative, then there is no option for that immediate relative to bring in their own child, the grandchild of the original petitioner. So the answer is not that clear, but if you didn't get all that, you can turn to a supervising attorney at the call-in.
Maggie, maybe an adjustment question?
No.
We'll take family.
If someone has left the U.S. and come back undetected, how can they trigger the 3 or 10-year bar?
Alan?
Well, if you do something wrong and no one finds out about it, nothing bad happens to you. If you do something wrong and someone finds out about it, something bad happens to you. So when we advise, as a practical matter, if nobody knows, then nobody knows. But when we advise people, we can never, as advocates, advise people to make misrepresentations. First of all, it's unethical to do so, And we have to play by the rules that apply to us as advocates. But secondly, you know, people do get found out, and it's risky. When you never know how it might come about that the government will find out some little factoid about you. I mean, look what happens to all these politicians who get in trouble for things that they thought nobody knew about or nobody was going to find out about. So that's the best answer I can give.
Monique?
Alrighty. For the purposes of the 245I, how do you find out about older applications that were filed for the beneficiary if the beneficiary or petitioner doesn't remember?
Midori?
So, as to how to get proof, I guess, that you have 245I so that you can adjust status. I guess there's several ways you can do it. I guess the easiest and the cheapest way is to file a Freedom of Information Act request, which is basically, did they cover that?
No.
Okay, so the Freedom of Information Act request is basically, the Freedom of Information Act is a law that says that the government can't hold information about you. You have the right to know what they have about you. And so a request can be made to the Immigration Service if you think there's a family-based petition. You can also make a request to the Department of Labor if you think that there was a labor certification filed for you, so that so you could get a copy of your records from the Immigration Service or the Department of Labor that would say, yes, there was a petition filed. It was it was filed on this date, or whatever other information the service has on you, they'd be able to send that to you.
Maggie?
Can a U.S. citizen, adult who's over 21, adopt and adjust a younger sibling who's 14 years old who overstayed his visa?
We'll give this to Julie. Part one of the question goes to Julie, and then Alan will take the rest.
Adoption's a little tricky. You have to be living with the family for at least 2 years, residing with the family for at least 2 years with respect to adoption in order for the adoption to count for immigration status. And the legal adoption needs to be completed by the 16th birthday. Now so if you're already 14, that might be a little tricky to get to 2 years before 16. There's some exceptions if there are other siblings involved who are being adopted at the same time. But what I would suggest, something that I don't believe we covered, but is it in the training materials, the special immigrant juvenile status?
I'm sorry?
SID, is it in the training materials?
Yes.
Only a little, but.
Okay, so there's something called special immigrant juvenile status, which would be a much cleaner way to go than an adoption. And there are a variety of requirements with adoption. I just mentioned some of the age issues as a starter. A special immigrant juvenile status case can be filed where you have an adult petitioner who petitions, and it can be either for custody or guardianship, so you don't even need an adoption, which is quite a long process, or even a custody order. You can simply get a guardianship order in family court, and with a guardianship order showing that the child has been abandoned, abused, or neglected by at least one parent, so you only need abuse, abandonment, or neglect by one parent, then you can go ahead and apply for a green card, and that would cover, there are a lot of waivers, more than your average number of waivers available to somebody applying for a green card on a theory of a special immigrant juvenile status petition. Again, that would be a more advanced question if we were to get it from a caller.
Can I ask you to read the question one more time, Maggie?
Can a U.S. citizen adult who's over 21 adopt and adjust a younger sibling who's 14 years old who overstayed his visa?
So now, let's assume that the adoption process was completed, like Julie said, before the certain age requirements, certain age limits were triggered. Alan, would the person be able to adjust to the United States?
So any individual who enters legally into the United States and who is an immediate relative of a United States citizen can adjust status, that is, interview here regardless of regardless of whether they've overstayed or worked without authorization. So the answer would be yes, but I would point out that I think Julie makes a very good point. Let's say the person, if I can just change the question, let's say that the child had entered without inspection, had snuck across the border, or been, as they say in California, had been crossed into the United States. Then there would be a problem with the adjustment based on the adoption, but not if the person's a special immigrant, correct? So in that situation, it might be better to go the route that Julie was talking about, where if the family court could give the over 21 person custody of the younger person, then that person could adjust status under the special immigrant rules and would not have to worry about the manner of entry into the United States.
And just one thing to keep in mind, some of these questions can get pretty complicated. And as Alan alluded to earlier, there will be supervising attorneys present at the call-in. You can, and you should reach out to them when questions come up that you're not familiar with. And then we also have our manual, which we handed out to you, should be in a plastic bag, which covers a lot of the situations that you will deal with at the call-in. Monique?
If you have a brother who is a U.S. citizen and a father who is a U.S. citizen, can both sponsor you? And who should file?
Let's send that to Midori.
Okay. So the question is, you have a U.S. citizen's sibling and you also have a U.S. citizen parent, and who should file for you? And
Which one's
the
better?
answer is both of them are eligible to file petitions on your behalf. From the discussion that we looked at with the visa bulletin, you'll see that it's usually going to be faster, sometimes significantly faster, sometimes not as much so when a parent files for a foreign national than when a sibling does, because I think the shortest wait on the sibling petition is like 12 years or something like that, 11, 12 years. So your brother can file for you, but the wait is going to usually be a lot longer. As far as who should file for you, they're both eligible to. I think that, if money's not an issue, then have both of them file for you, because, you can have as many petitions going as you're eligible to have going for you, and then whichever one comes through first is the one that you'll end up getting your permanent residence through. So if if your father's 96 years old and not very healthy, there might be a shorter waiting list to get it through your father, but if he passes away before the petition's approved, then you won't be able to use that anyway. So, in that case, it might be better to have your brother file. There's all different kind of things like that, but to consider when you're making your decisions. But as far as what the law allows, you can have as many petitions going as you like. So all other considerations aside, if you can afford it, have both of them file.
Julie, do you want to add something?
I just wanted to add, in my regular day job, I specialize in unhappy families that aren't getting along. And because of that, it's not only, the I-130 petitioner can pull the petition at any time before the sponsored family member gets a green card. And they're going to need to cooperate until the bitter end, as it were. And so my theory is, even if you can't afford it, I would try to stretch your budget just a little bit more, maybe borrow some money. I would get every I-130 on file that's possible. If you have 7 family members who can file I-130s for you, get 7 to file for you. You never know. It's not only how fast each line's going to move, it's not only could somebody die or could something else happen? You really just don't know the future. And your best protection against the future, against the variety of things that could happen to the petitioner themselves, between you and the petitioner, it's really, from my perspective, a good idea to get as many I-130s on file until such time as you have a green card.
We have time for maybe 2 more questions. Maggie?
Okay. What is the penalty for a U.S. citizen who marries and petitions for a non-citizen for immigration benefits only?
Alan?
Repeat the question again, please.
What is the penalty for a U.S. citizen who marries and petitions for a non-citizen for immigration benefits only?
Well, there are criminal penalties, but they're usually not. If it's a single time, in other words, they get popped at an interview, and the person confesses that it wasn't a bona fide marriage, they typically do not prosecute those cases. The cases they tend to prosecute are people that get, like, every 2 or 3 years they get married to help somebody get a green card, and you don't see that very much because they're not approving the cases. I mean, back in the day they did. So I don't think it's a significant concern, but of course it's discouraged.
Julie, you want to add something?
Sorry, I'm talkative. I want to add a couple of reasons, in addition to the fact that it's a felony, not to do it. And I would say both for the citizen petitioner and the non-citizen beneficiary. As a non-citizen beneficiary, once you have filed a fake, been involved in applying for a green card based on a fake marriage, you are never, ever, ever ever, under any circumstance, eligible to get a green card based on an employment-based petition or any family-based petition. So it's really not uncommon for me to see people who had a fake marriage, maybe in the 1970s, 1980s. The green card application didn't go through. Today, they do have a qualifying family member who wants to sponsor them. They are dead in the water. Similarly, that citizen may have a, for immigration purposes only, marriage with that non-citizen, but at some future date, they may want to sponsor a non-citizen for a green card based on a marriage or some other family member. Once immigration thinks you've lied to them, it is going to be a very, very tough row to hoe. Now, for the beneficiary, the non-citizen beneficiary, it's a permanent bar to family-based and employment-based marriage. It's not a permanent bar for the U.S. citizen petitioner, but I can tell you, I'm not sure I'd be willing to represent you if you subsequently have a real marriage petition you want to go forward on.
I have a sentence too.
I'm sorry?
I have one sentence.
Yeah, go ahead, Midori.
So you know this is a good question because we all want to chime in on it. We did look at that question as far as what the penalty is. Like, it should be on the I-130 at the section where the petitioner is going to sign it, but the penalty is if you're convicted of this, it's a $250,000 fine or 5 years in jail or 5 years in jail. So, you know, it may not be something that happens every day, but if it happens to you, then, you know, it doesn't really matter if it happens every day
All
or
right,
not.
good point, Midori.
All right.
And last question from Monique.
Follow up on the case study with Angela. So she's 18 years old. She has a son. At the time of filing, the mother's an LPR. The mother becomes a U.S. citizen. What happens to Angela and her son?
We might need to revisit those facts. Do you have another question?
We got it.
You do?
Julie
Okay,
has
go ahead.
it.
You'll get it.
So that was my question. So I think there's two things that go on here. So if a green card holder files a petition, an I-130 petition, for their unmarried child, again, remember, there is no such thing as an I-130 petition of a green card holder for a married child, but the green card holder files for the I-130 for the unmarried child, you get an automatic, and then the petitioner, the mother, becomes a U.S. citizen, you get an automatic bump up. Now, depending on the age, I think I wrote the age carefully. In the question that I wrote with a child named Angela, she was born in 1978, so she hasn't seen the other side of 21 in a really long time. But if the person is close to 21, maybe they're 22, 23, it's going to be whether or not, when the mother becomes a citizen, whether the child gets to be an immediate relative, which is something they would get to be if they were under 21, either in reality or based on the formula of the Child Status Protection Act, or whether they go to preference category 1 for unmarried children of U.S. citizens, is going to be a careful calculation based on the Child Status Protection Act. I would say, however, that if Angela is herself a mother, so her mother is a U.S. citizen now, and filed an I-130 for her, and she herself has a baby, she's not going to want to come in as an immediate relative because she'll have to leave her baby behind. So she might want to wait it out until she's over 21, not only in reality, but over 21 in Child Status Protection Act years, so that she can convert, as happens automatically. You don't have to do anything. It just happens by operation of law. She's probably going to want to be a preference category 1 relative, because when her priority date becomes current, she can bring her child. So in this scenario, you may have a green card holder who files for her 18-year-old daughter, that's preference category 2A. The mother may become a citizen, and you're going to hope that by that time that child is over 21, and that can become a preference category 1 through that process. If she already has a child, she's going to want to be preference category 1. But if she's treated as under 1, she's going to be an immediate relative. The point of that view, you could be preference category 2A, immediate relative, preference category 1, is the I-130, a single I-130 can just be filed and sit there, and because of changes that happen, the petitioner becomes a citizen, the child gets older, becomes over 21, the preference categories can change, and you can flip in and out of being a preference relative or an immediate relative.
Thank you. We're about to break for lunch. Please put your clickers in your plastic bags and bring them back for the afternoon session. You'll need them. And when you do leave, please return the clickers to the registration table. But can we have a round of applause for our panel, please?